Welcome back to the Constitutional Clarion. On Saturday the 20th of April, a press release was issued announcing that two people were going to stand as job-sharing candidates for election for the electorate of Higgins at the next federal election. Now, it was obviously a fairly slow news day because a number of media organisations picked that up and reported it rather uncritically as fact. But the Guardian newspaper was at least curious and did ring me up to see whether or not I thought that it was constitutionally or legally valid. And indeed, one of the good viewers of the Constitutional Clarion also inquired of me about that. So this video is about whether such a job sharing arrangement is legally or constitutionally possible. The two aspiring job sharing candidates, Bradlow and Bock, said this on their website about the proposed arrangement, and this is a direct quote. According to our research, there are no legal barriers to the inclusion of two candidates in either the Commonwealth of Australia Constitution Act or the Commonwealth Electoral Act 1918. Then they went on to say, Section 163 of the Commonwealth Electoral Act simply describes the characteristics that would make a person eligible for nomination. It does not specifically state that the job must be done by one person or a single member. They went on to say, Part 3 of the Australian Constitution sets out that the number of members of the House of Representatives can be altered as necessary to accurately represent constituents without specifying the number of members per seat. And finally, they said in this regard, Section 34 of the Constitution places only two limitations on eligibility for selection as a member of the House of Representatives, that one be 21 and one be a citizen of Australia. Well, where to begin with what is wrong with all of that? Even that last claim about Section 34 shows a really basic misunderstanding of both the Constitution and the law. Section 34 does contain a far more important qualification, and that is that a member be an elector who is entitled to vote for the House of Representatives or a person qualified to become such an elector. And obviously, to become an elector, there are other qualifications that you need to meet. Section 34 also includes a residency qualification as well. But of course, Section 34 applies until Parliament otherwise provides. And Parliament has, of course, otherwise provided. So that means you don't have to be 21 to be a member of Parliament. You can actually be 18. And Parliament otherwise provides for that in Section 163 of the Commonwealth Electoral Act. So what does this show us? Well, just simply that there is a lot of confusion going on here about the interaction between the Constitution and legislation. As for there being no legal barrier in the Commonwealth Electoral Act to this plan, what about Section 57 of the Commonwealth Electoral Act? It says this: one member of the House of Representatives shall be chosen for each electoral division. Couldn't really be much clearer than that, could it? So, if you wanted to choose two job-sharing members, then yes, you would have to amend the Commonwealth Electoral Act, not only in relation to Section 57, but also in relation to the nomination form, the form of the election writs, and also numerous other provisions to make the Act actually workable in relation to job-sharing arrangements. It is possible that Bradlow and Bock think that they can each exercise the office of a single elected member of Parliament so that there would only be one member for the electoral division of Higgins, but two people actually fulfilling the duties of that member. But this would seem to be contrary to the Constitution because the Constitution treats a member of Parliament as a person rather than an office that can have its duties fulfilled by more than one person. For example, before a member of Parliament can sit or vote in the House, Section 42 of the Constitution requires that person to be sworn in as a member of the House of Representatives. It does not permit two or more people to be sworn in as a single member. Equally, all the provisions in the Constitution that concern qualification, disqualification, and resignation are directed at a single person being qualified, disqualified, or resigning. The Constitution simply does not contemplate a member being comprised of two or more persons who are subject to different qualifying or disqualifying circumstances. While Bradlow and Bock have stated that if one of them resigns or becomes disqualified, that would mean then that both of them would be, that's just their view of what would happen. There's nothing in the Constitution or the legislation that actually addresses the issue, because both the Constitution and the legislation are predicated upon there being a single member who is an individual person. Bradlow and Bock also suggest on their website that they would each be regarded as a member. They say that the Constitution sets out the number of members of the House of Representatives and that this can be altered as necessary to accurately represent constituents. Well, yes and no. There are some constraints that politicians have tried and failed to get removed in referendums in the past. Section 24 of the Constitution says that the House of Representatives shall be composed of members directly chosen by the people, and that the number of such members shall be, as nearly as practicable, twice the number of the senators. So if you increase the number of members in an electorate in the House of Representatives through job sharing, you would have to reduce the number of electorates so that the overall number would not be more than twice the number of senators. Section 24 then goes on to set the number of members for each state by reference to that state's proportion of Australia's population. So no, you could not expand the number of members in Higgins to 2 without taking away a member from another electorate in Victoria, or without, in effect, having to redistribute every electorate. But of course, this would not be possible because you couldn't know in advance how many electorates would elect how many job sharers as their members. It just wouldn't work at all without some kind of a constitutional amendment. There are other provisions in the Constitution that are also tied to the number of members. For example, Section 39 sets the quorum of the House of Representatives by reference to a proportion of, quote, the whole number of members of the House of Representatives. How would that work when half the job sharers don't turn up each week? But the quorum at least can be changed by legislation. Other provisions cannot. Section 33, for example, refers to the election of, quote, a new member, unquote, to fill a vacancy in the House of Representatives, not 2 or more job-sharing members. Section 37 refers to the resignation of a member. It does not deal with the situation of one job sharer deciding to resign. If each of the job sharers, having been sworn in as members of Parliament, turned up to vote in the House at the same time, each would be fully entitled to vote, giving their electorate double representation. It's not enough to say that they have an arrangement amongst themselves that they will each attend on separate weeks. This would not remove their legal entitlement as a member to attend or vote. Further, any contract that constrained a member from exercising his or her right to vote would be invalid because it would be treated under the law as a contract for an improper purpose. All up, the proposal is just not functional under the Constitution and the law as it is. So to make it work, you would have to have both legislative and constitutional reform. If the people of Australia agree that job sharing amongst politicians is a great idea and that it wouldn't lead to political chaos with votes being taken one week being overturned the next week when different job sharers turn up to Parliament, then of course they could approve a referendum to make such a change. But any such proposal would actually have to be more seriously considered before being put up for constitutional change. Thank you for watching the Constitutional Clarion, and thank you for your suggestions for future Clarions, and I look forward to seeing you next time. Goodbye.